plans by the Rwandan government to kill them. In 2021, the UK government criticised the Rwandan government for extrajudicial killings, deaths in custody, enforced disappearances, and torture. There are also concerns about media and political freedom in Rwanda. Since Rwanda has ratified many international human rights conventions, this evidence raises questions as to its compliance with its international obligations. It's also relevant to the question whether the Rwandan courts can be expected to act independently of the Rwandan government when deciding appeals against the Rwandan government's decisions on asylum claims. Secondly, UNHCR's evidence is that there are systemic defects in Rwanda's procedures and institutions for processing asylum claims. To mention only some of the points raised, they include, first, concerns about the asylum process itself, such as the lack of legal representation, the risk that judges and lawyers will not act independently of the government in politically sensitive cases, and the fact that the right of appeal to the High Court, which has existed in theory since 2018, has never, in fact, been exercised. Secondly, Rwanda's 100% rate of rejection of asylum claims from countries in known conflict zones from which asylum seekers removed from the UK may well come, such as Syria, Yemen, and Afghanistan, although the UK authorities often find that such claims are well-founded. Thirdly, Rwanda's practice of refoulement, of which UNHCR gave over 100 examples, which continued during the period after the UK's agreement with Rwanda was concluded. And fourthly, the Rwandan government's apparent misunderstanding of its obligations under the Refugee Convention. The third matter raised in UNHCR's evidence is Rwanda's failure to fulfill undertakings which it gave to the government of Israel under an agreement for the removal of asylum seekers from Israel to Rwanda, which operated between 2013 and 2018. In terms of the agreement, asylum seekers sent from Israel to Rwanda were to be allowed to claim asylum there, and there was an explicit undertaking by Rwanda to comply with the principle of non-refoulement. The agreement was therefore similar in those respects to Rwanda's agreement with the UK. Despite the terms of the agreement, asylum seekers who were sent to Rwanda by the Israeli government were routinely moved clandestinely to a neighbouring country from which they were liable to be refouled. That evidence is not contradicted, and it raises a serious question as to whether the undertakings given by Rwanda under its agreement with the UK government can be relied on. As I've explained, the legal test which has to be applied in this case is whether there are substantial grounds for believing that asylum seekers sent to Rwanda would be at real risk of refoulement. In the light of the evidence which I have summarised, the Court of Appeal concluded that there were such grounds. We are unanimously of the view that they were entitled to reach that conclusion. Indeed, having been taken through the evidence ourselves, we agree with their conclusion. We accept the Home Secretary's submission that the Rwandan government entered into the agreement in good faith, and that the capacity of the Rwandan system to produce accurate and fair decisions can and will be built up. Nevertheless, asking ourselves whether there were substantial grounds for believing that a real risk of refoulement existed at the relevant time, we have concluded that there were. The changes needed to eliminate the risk of refoulement may be delivered in the future, but they have not been shown to be in place now. The Home Secretary's appeal is therefore dismissed. There is also a cross-appeal on behalf of one of the asylum claimants who argues that the Rwandan policy is in breach of retained EU law, as well as being unlawful for the reasons that I've already explained. We reject that argument on the basis that under an Act of Parliament enacted in 2020, the EU provisions in question ceased to have effect at the end of that year. The cross-appeal is therefore also dismissed. The Court will now adjourn.
Asylum seekers to Rwanda. Seeking asylum is not trying.
Great news! Well done!
They trying to find a different way to deport people back, people who are flee from their country because of war, because of insecurity. But unfortunately,
what's the rate?
Got a camera. Do you want to do it with her face? Like, we could do it up there and then do it with the camera there. Yeah, makes sense. Could you do it up there, I think?
I'm Sheila Reynolds. I'm the head of Asylum Advocacy at Freedom from Torture.
Sheila S-I-L-E, Reynolds,
N-O-L-D-S.
What does this mean?
This is great news. This means this is a victory for reason and compassion. The Supreme Court has upheld the decision of the Court of Appeal that the government's Cash for Humans scheme to send refugees to Rwanda is unlawful. And we are delighted. The Supreme Court has affirmed what we and our supporters and compassionate people across this country knew all along, which is not only that this immoral scheme is wrong, but that it flies in the face of the laws of this country.
What does this mean for victims of torture?
the stakes of this judgment couldn't have been higher. Our clinicians have seen every day in the clinical services that they've been providing to survivors of torture just how terrified, just the pure fear that this scheme has inspired in refugees. So for them, this judgment is a really important day. They will be able to breathe again.
What does this mean for the UK's position in the world on human rights?
Well, it will be interesting to see how the government responds to this. It's a fairly unequivocal statement that an attempt to send refugees to a country like Rwanda is unlawful. Other countries will be looking today at the decision of the Supreme Court and will be